So our first story might be something you're familiar with if you're a fan of this channel and if you've watched other videos on my channel, which you probably haven't, let's be honest here. So the first story involves Spencer Eldon versus Nirvana. Now, if you've seen this on the news or, as I said, on the videos on my channel, Spencer Eldon is the baby that was on the cover of Nirvana's album Nevermind. And if you've ever seen that album cover, it basically involves a nude baby swimming naked, chasing a dollar bill on a fish hook. That baby, Spencer Eldon, is now 30 years old, and he sued Nirvana, saying that cover and him on that cover was child sexual exploitation, that taking the picture was sex trafficking and all kinds of nasty and terrible things because of that picture. So in my original video, I covered the August 24th complaint that was filed by Spencer Eldon and kind of went over all his claims and whether they had any merit and what I thought would happen with this case. Since that time, there's been some developments. So first thing I wanted to note, there was an amended complaint filed on November 22nd by Spencer Eldon. And usually what this happens when the plaintiff wants to change some things, maybe new evidence came out, they discovered some things, maybe they had more time to research the law, and they decide to make some changes voluntarily. But after this, December 22nd, 2021, we have a motion to dismiss filed by the defendants, so Nirvana and all the parties. And it seems that the plaintiffs, and this is how I'll mark the plaintiffs, it's a P. So the plaintiffs failed to respond to that motion, and as a result, the judge and the court granted the motion and dismissed the complaint. That's it. That means the lawsuit's over, right? Well, sort of. The court gave until January 13th for the plaintiffs to refile their complaints. So they did. On January 12th, 2022, they filed their second amended complaint. And that's sort of what I want to talk about is what's in that amended complaint and what changes did they make? What did they think were the issues and where did they think they didn't have to make changes? So here is the motion to dismiss. It's all going to come down to two main arguments. Argument number one, first cause of action for alleged violation of the federal child CP statute brought under 18 U.S.C. 2255 is barred by the statute of limitations. So quick and easy, it's too late to bring this claim. Second argument, federal sex trafficking statute brought under 18 U.S.C. 1595 cannot be sustained because the alleged trafficking occurred before the enactment of a civil cause of action. In other words, the statute came out in 2003. He's saying the trafficking occurred in the 90s. You can't sue based on something that didn't exist. So here's that statute of limitations I mentioned. And I talk about this in my video as well. Any action commenced under this section shall be barred unless the complaint is filed not later than 10 years after the date on which the plaintiff discovers the violation that forms the basis for the claim or the injury that forms the basis for the claim, or not later than 10 years after the date on which the victim reaches 18 years of age. So if he was 10 years old when he discovered it, that doesn't matter. He gets a bonus 8 years from 18, 10 years from that date. He should have brought that claim. He's 30 or over 30 at this point, so it's too late to bring a claim. But really what we want to focus on is injuries after 2011. Stuff before 2011, let's throw that out. It's too late. What about post 2011? Well, Eldon cannot sue separately for violations that post-date August 2011. And why is that? Argument number one. Eldon has not pled post-2011 violations as to any particular defendant under the Iqbal-Twombly standards. Basically, under Iqbal and Twombly, you have to be particular with your pleadings. So the pleading does not separately identify any particular violation by any particular defendant that occurred after 2011. Eldon must identify what each of the 11 defendants supposedly did after August 2011. He did not do so. The complaint must specify the particular conduct on which each individual defendant's liability is alleged to be based. He doesn't do this. There's no particular conduct being alleged. If you read the complaint, all it says is the defendants disseminated, they reproduced CP. Well, how did they do that? In fact, Eldon's allegations fail to state a timely claim under the statute against any defendant based on any particular conduct. As to many of the defendants, there is no possible claim that post-August 2011 conduct could be at issue, particularly in light of the plausibility standard and certifications that must be made under Rule 11. Rule 11 talks about representations to the court. Essentially, this is saying you have to have some kind of basis for what you're arguing, what you're complaining about. If you don't do that, if you're just making stuff up, you're subject to sanctions, potentially. Sanctions are basically a punishment on the attorneys or the parties that violate the rule or are responsible for the violation. So what's happening here is by citing Rule 11, Nirvana's almost like setting a trap, setting a warning to the plaintiffs saying, look, you have no possible claim. You're just making stuff up at this point, and this is a frivolous argument. And I think this is sort of the main argument here, which is Eldon's pleading claims that he was victimized by one long-running course of conduct undertaken by a single group of defendants who created the photograph, put it on the cover, and then sent it into mass circulation. All the issues with this complaint are summed up in here. You're lumping all the defendants in as one party. They should all be separated out. It bears repeating. Eldon's claim is that the same kind of victimization was done by the same group of defendants and in broad daylight at all relevant times. If he had sued in 2010 or before, Eldon would have been asking for precisely the same kind of relief he is asking for now. So what's the point of a statute of limitations if you're just going to sue for the same exact thing 20 years, 10 years, 30 years after the fact? What would stop him from suing for this for the same reasons in 90 years? And what's he even suing for? He's lumping all the defendants in as one party. So here is the verified second complaints. Still has all those parties, still has Kirk Weddle, still has, David Grohl, still has Kurt Cobain's estate. You will notice they threw out the 1595 sex trafficking claim. Now you only have the CP claim. And they've sort of reframed this lawsuit as saying this is a suit for damages arising out of defendant's violations during the 10 years preceding the filing of this action. So they're only talking about the last 10 years. Anything before 2011, August 24th, 2011, doesn't matter anymore. But the same issue still exists. They're lumping the defendants in together and not specifically saying what each defendant is guilty of. During the 10 years preceding the filing of this action, each defendant knowingly possessed, transported, reproduced, advertised, promoted, presented, distributed, provided, and obtained CP. How? How did any of them do this? It's too broad. It's just restating exactly what the statute is. So it's just copy and pasting basically what the statute is, but it's not saying how they're doing any of this. Continue to knowingly possess, so saying Nirvana and all the parties being sued, continue to knowingly possess, transport, reproduce, advertise, promote, present, distribute, provide, CP, all in violation of the criminal statutes. But again, it's not saying how each one is, what each one did. For example, did David Grohl sell these on the street? Did Kirk Weddle buy a bunch of these and hoard them in his house, in his closet? It's not saying any of these. So you can't defend yourself if you don't know what you're being accused of. For example, how do you defend yourself against all of this? The only logical answer is no, I didn't do X. You have to have a specific thing you're arguing against. For example, David Grohl continued to knowingly possess the album cover through this date and this date, or we expect with further discovery, he continues to possess it and owns it in this manner or this manner. So then he can say, no, I disagree with that argument or that fact. I mean, this is a really hard thing to prove for either party. Did you own it or not? At what dates? But he's not laying out any dates. He's not arguing anything. I don't understand why they would even lump them in together. This is only hurting their argument and increasing the chances that the judge is going to throw this out on his face. So as you can see, I've kind of went through this and I didn't see anything that kind of fixed the main deficiencies that were argued against in the motion to dismiss. In other words, I don't think they're going to be able to overcome another motion to dismiss, and this lawsuit might just get thrown out with prejudice because they've had a chance to amend it, so many times now. There's really nothing in this amended complaint that fixes some of the main issues. Now you don't have any claims before 2011 for things that happened before 2011. You don't have the sex trafficking claims anymore. All you're left with is injuries that happened after 2011. And even for those, you still haven't separated out the defendants. So you still have the same major issue of not pleading with sufficient particularity and not stating plausible claims. Again, defendants, plural, widely commercialized the Nevermind album cover. How did Kirk Weddle commercialize the album cover? Here it says Geffen Records originally shipped just 46,000 copies of Nevermind to retailers. Why is this even in here? When did this happen? You need a date. You can't just randomly state this. Did this happen after 2011? Because if it did, that's a plausible claim. You shipped this CP this number of times and sold this many copies, or plan to sell this many copies. This is what it should look like for all these parties. But again, doesn't say the year. I'm guessing this happened before 2011, which is why they omitted the year. Here is just going through the factors. If you want to get a deep dive of these factors, I talk about them in my other Nirvana video. Let's finish off here by kind of reiterating what Spencer Eldon is arguing. Spencer has and will continue to suffer personal injury from the defendant's possession, transportation, reproduction, advertising, promotion, presentation, Are we sure they're doing all of this? Again, it's the same issue. The only thing that I would guess someone like Kirk Weddle might be guilty of is possessing if he owns a copy of the album like many of us do, but you're not being specific. He should have been specific and said Kirk Weddle possesses it. This person transports it because this is his role and this is what he does. I just highlighted again, lumping them all in together. Each defendant knowingly possessed. Each defendant knowingly received, distributed. Each defendant knowingly reproduced. I don't see any facts supporting this. Each defendant knowingly advertised. I don't see this going very well for Spencer Eldon. I don't know what the court's going to do. I'm guessing the next step is Nirvana is going to file another motion to dismiss, and they're going to respond to that motion to dismiss, and then we're going to get a ruling by this court as to the motion to dismiss. And I'm guessing because they didn't separate out these defendants, there's no plausible claims against people that haven't been involved since 1991 or 92. I think the court's going to dismiss it. Now, the only question is whether it's going to be dismissed with prejudice or without prejudice. Meaning, can they file another amended complaint? Because they've already done so, who knows? It's possible the court will just dismiss it with prejudice and say, look, this thing's done. It's also possible they'll dismiss it with prejudice or without prejudice and basically let them amend the complaint a third time. We'll see what arguments they'll come up with then. But until then, that's all she wrote on this one. It's an interesting case, and the more I read it, the more frustrated I get. Well, it's happened again. Netflix has been sued because of its hit documentary, Tiger King. And this time it's for using movie clips without permission. Specifically, movie clips from the hit film Ace Ventura. So here's the complaint. It's in the Central District of California, the Western Division. It is Morgan Creek Productions for copyright infringement. So I'm guessing they are the owner of the copyrights for Ace Ventura, Pet Detective. And it is against the defendants, Good Films, LLC, and Netflix. So this is a civil action for copyright infringement under the Copyright Act, so pretty standard there. So here are the sort of the allegations. So in the two clips from Ace Ventura 2 used by the defendants without permission or license, Mr. Carey appears first with a monkey wrapped around his neck and shoulder, and then in an unrelated clip triumphantly riding an elephant. Together they comprise approximately 5 seconds of screen time. Here's one of the clips with the monkey, and here's the one with the elephant. If you actually go and watch the episode, it's more like 1.5 seconds to 2 seconds. It's not 5 seconds. So it's kind of strange that they would use the wrong time in their complaints. I think maybe the whole segment where the movie clips play is 5 seconds because there's other movie clips from The Jungle Book, I believe. So it's not like this is just Ace Ventura that's playing. And it's playing during a voiceover that's talking about Doc Antle, which is one of the tiger owners, and saying how his animals were used in various movies, including Ace Ventura. So that's when he mentions Ace Ventura, and then they play literally like a flash. It's like a picture almost. It's not even really a movie clip because it's so quick. And then they played some of the other movies he was in. The only difference is Ace Ventura is the only movie where there's 2 1 second maybe clips or half a second clips played. For all the other movies, it's just one. But there's different animals in the clip. So maybe they want to show that there was a monkey used from Doc Antle or from these tiger owners and an elephant used. For the other movies, maybe that wasn't applicable because it was only one animal used. The sequence with these clips appear in Tiger King, featuring movies where various wild animals such as tigers, panthers, monkeys, so there's one, and great apes appear. Didn't mention elephants. Leaving no room for doubt as to the source, a dubbed over voice identifies each movie as Ace Ventura at the precise time when the infringing clips appear on screen. Ace Ventura is the only film used in Tiger King where more than one clip appears. So they're trying to say, look, this isn't fair use. They're already thinking about the fair use counter argument. This isn't fair use because they used more than they needed to. They used 2 clips. They could have just used 1. Tiger King's going to argue, well, we used 2 clips because there's 2 different animals that were used and we wanted to highlight that, not because it added some kind of entertainment value or something like that. So this is kind of where it gets silly. On information and belief, defendants financially benefit from their use of the infringing clips because their appearance of the 2 comedic scenes from Ace Ventura 2 serve to enhance the commercial value of Tiger King by demonstrating the frequent use of wild animals in various cinematic productions, adding levity to the first episode, an important factor in driving traffic to the episode of Tiger King which follow, and indicating by inference that the makers of Ace Ventura 2 are promoting Tiger King favorably. So what's the issue? Whenever you're looking at copyright infringement and fair use, you're asking yourself, is this infringing on the potential market for Ace Ventura 2? Well, no one's going to watch Tiger King to get the experience of watching Ace Ventura 2. Of course, there are situations where sometimes people like react channels that you see on YouTube, if they play 90% of a film, well, people might not even go to watch the film on HBO or something. They could just watch it on YouTube through the React channel and get the same experience. And then it's infringing on that main market of content consumption. But for things like this, where it's extremely short, The market that's being infringed is the licensing market. So it's the market where these companies go through these negotiations to license their clips to other creators to make documentaries and things of that nature. So one thing I highlight here, which is pretty interesting, is a quote made by Mary LaFrance of the University of Nevada. The reason there's a market at all for clips this short is that people can't afford to litigate fair use. So these would be fair use in most cases, and the market for clips exists because people are scared of lawsuits, so they rather just pay up. You have a market because fair use isn't being applied, and if you apply fair use, you might not get fair use because there's a market. So here is just restating what Morgan Creek's argument is, saying the clips help the docuseries by demonstrating use of wild animals, adding levity, and suggesting Ace Ventura's producer supports the docuseries. The funny thing is that first sentence, they help the docuseries demonstrate use of wild animals in films, almost sounds like they're describing what a fair use would be. We didn't use this to add entertainment value, we use this to demonstrate use of wild animals in film. We use this to show a different side of Ace Ventura. Ace Ventura's purpose was to be a comedic film for entertainment. The purpose of these clips was to demonstrate that animals owned by these tiger owners are used in film, and you can see them in these kinds of major blockbuster films. So it's funny, it's like they're giving the fair use argument to the other side. And here's the part that I mentioned, it's actually about 1.5 seconds combined, shorter than claimed in the complaints. So if we can say there is a potential market harm, the question is whether the work was transformative, whether it created something new to a sufficient extent that it should be granted despite the fact that they didn't license. Because we want discourse, we want commentary, we want critique. We don't want people to be able to freeze, let's say, movie critics from criticizing a movie by the company saying it's copyright infringement if they show a clip of that movie. So Tiger King's probably going to argue fair use. And here are some of the best practices in fair use to kind of consider what they might argue. So whenever you're looking at fair use, you're asking yourself these key questions. Did the unlicensed use transform the material taken from the copyright work by using it for a different purpose than the original? Or did it just repeat the work for the same intent and value as the original? Let's say I recut Ace Ventura to make it a shorter film with just the best jokes. That seems close to the same purpose for which the original film existed, so that might not be fair use. But if I'm critiquing the use of animals in the film and showing how they're mistreated in the film or something like that, then that might be a transformative purpose because it's a whole different purpose than the original movie. And then the other question is, was the material taken appropriate in kind and amount? So if you use an hour of Ace Ventura to make your point, that seems too much. That seems like you're just putting it there for background noise so that people have an entertaining thing to look at while you're making your arguments. But if you use 1.5 seconds, well, that's barely any part of the whole movie. No one's getting any entertainment out of that. All it's doing is illustrating a point. And some of the best practices for different types of fair use are commenting on or critiquing the copyrighted material. So commentary may be explicit, as might be achieved, for example, by the addition of narration, or implicit, accomplished by means of recasting or recontextualizing the original. In the case of negative commentary, the fact that the critique itself may do economic damage to the market for the quoted work, as a negative review or a scathing piece of ridicule might, is irrelevant. So this is our movie reviews, our commentaries, and things of that nature. But these come with a limitation. That limitation is the use should not be so extensive or pervasive that it ceases to function as a critique and becomes instead a way of satisfying the audience's taste for the thing that is being quoted. In other words, the new use should not become a market substitute for the work. Another best practice for fair use is using the copyright material for illustration or example, which is, I think, sort of what this fair use is going to be for Tiger King. So sometimes video makers quote copyright material not in order to comment upon it, but because it aptly illustrates an argument or a point. So Tiger King's making the argument that wild animals were used in various major Hollywood movies and that these wild animals came from zoo owners such as Doc Antle and Joe Exotic. And how are they illustrating this point? By showing a series of movie clips that have these animals in the films. So this kind of use is fair when it is important to the larger purpose of the work, but also subordinate to it. It is fair when the video makers are not presenting the quoted material for its original purpose, but to harness it for a new one. This kind of use is thus creating new value, which is, I think, what is happening here. To the extent possible and appropriate, illustrative quotations should be drawn from a range of different sources, which is why that complaint mentions Ace Ventura is the only one that has 2 clips. So it's almost like it's saying, well, why is Ace Ventura the one with 2 clips? There's something different about that. It's almost making Ace Ventura seem special. People are going to think that we somehow endorsed Tiger King. And this also goes to the point of the clip should not be longer than necessary to achieve the intended effect. You could have achieved the intended effect by just having one clip, but you chose to have 2 clips. Again, I think the counter argument is no, we wanted to show different animals, and Ace Ventura was one of the only movies that included 2 different animals. I think this is a pretty frivolous lawsuit, to be honest. I think this is an open and shut case of fair use. But the issue with this is that, well, fair use, it's going to be a question of fact, and it's going to have to go through discovery and things like that, unless Netflix argues that this is a slap lawsuit. So a slap lawsuit is a strategic lawsuit against public participation, or an intimidation lawsuit. It's intended to censor, intimidate, and silence critics by burdening them with the cost of a legal defense until they abandon their criticism or opposition. In a typical slap, the plaintiff does not normally expect to win the lawsuit. The plaintiff's goals are accomplished if the defendant succumbs to fear, intimidation, mounting legal costs, or simple exhaustions and abandons the criticism. So essentially, it's a frivolous litigation that's filed by someone in bad faith to basically scare someone off from conveying their message. Some jurisdictions have actually passed anti-slap laws, so they'll basically allow you to throw out a lawsuit pretty early before getting to the fact-finding stage by saying, look, this is a slap lawsuit. These laws often function by allowing a defendant to file a motion to strike and or dismiss on the grounds that the case involves protected speech on a matter of public concern, which is sort of what this documentary is. The plaintiff then bears a burden of showing a probability that they will prevail. So they'll actually consider the fair use maybe at an earlier stage than they would normally, because they're going to argue this is a slap lawsuit. It's only meant to intimidate. So what might happen with this case? Well, we either will have a response, basically arguing, denying the allegations or claiming fair use as a defense, or we might see a filing of a anti-slap motion to strike. So we'll see if that's the way this goes. And I'm always interested in these kinds of cases because fair use is something that's very subjective. It's up to a lot of dispute and you never know which way it's going to go. So who knows? It could go either way. If you're somebody who's pretty active online, you've probably heard of Dmca, and specifically Dmca takedowns. Most of you might be familiar with this from YouTube. Whenever you have a YouTube video that has some copyright infringing content, you see a Dmca takedown, and essentially these videos get taken down by YouTube's content ID system or something of that nature if they're not manually taken down. Well, lately Dmca has been particularly prevalent with Twitch. Twitch is a streaming platform where people essentially have live streams of their gameplay and daily lives, and specifically there's been a recent trend of Twitch streamers streaming full TV shows or movies and reacting to them. And reacting, I'm kind of using that phrase generously here because in some cases they're simply sitting there and essentially playing a TV show or a movie in its entirety. So it's hard to see how that would be fair use given they're not really giving much commentary and they're pretty much playing the whole thing, thus replacing that in the market. Recently, it seems some of these bigger companies such as Viacom and Fox have essentially started coming after these Twitch streamers who have been streaming these full television programs. Particularly here, you'll see the story I'm using as an example is the Twitch streamer Pokimane, who received her first Twitch ban because of streaming Avatar: The Last Airbender cartoon. Pokimane was watching this episode live, and then she received a live Dmca ban. And I believe this was because someone manually filed a Dmca notice to take down the content. So an interesting thing about this article here that I'm looking at while we're talking about Twitch streamers using various content, you'll see here it says, I can see at least half a dozen streamers in the just chatting category watching old animated shows and wrestling events. Of course, almost all of this content is owned by large companies who usually aren't too keen on random people broadcasting their copyrighted material, so it's not shocking that even a big streamer like Pokimane would encounter some legal pushback in the form of a Dmca ban for streaming TV shows. And to give some background of what these Twitch streamers have been doing is watch these videos live with thousands of people watching with them, and they then delete the VODs, which are the recordings of their live streams. So there's really no evidence of this happening. They removed the option for clips to be made, so you can't make little clips of their streams. So if you're a big company like Fox, it's really hard for you to even detect that someone is infringing on your copyright. Oftentimes these lawyers who are dealing with tracking copyright infringement, they're often pretty behind in terms of when something's infringing, unless they're actively looking for it. So let's say you have a new movie coming out. Let's say you have a new Spider-Man movie coming out, and then there's someone leaks the whole movie on YouTube. You're probably on the lookout for stuff like that, so you'll be quicker to shut that down. And that's a true story. Something like that did happen I believe it was up for a few days before whoever Sony was able to take it down. But for something such as old TV programs, and specifically old TV programs because they might not have an active enforcement team looking out for infringement because the program's no longer really lucrative. So in cases such as that, such as Avatar, you might not have lawyers looking out for this kind of infringement. And if you don't have the evidence up, they had to have been watching live or someone must have tipped them off for them to actually file a manual DMCA claim. But now that they filed one and filed another one for MasterChef, a different company, now you're starting to see sort of a trend that these companies are probably going to be actively looking out. They might have an intern or paralegal looking at these platforms live just to look at who's streaming what and then file live DMCAs. So some background. The reason DMCA was created was because Congress was sort of fearful the internet, which was still uncertain at that point, would never be able to really expand or form if various internet service providers would get shut down because someone on their site posted something that was infringing copyright, which is why DMCA created this sort of safe harbor. So the safe harbor shields online service providers from infringement claims made against them based on the conduct of their customers or users. So Twitter, let's say you have Twitter, you have all these users. Twitter itself isn't posting content. So if someone has something that infringes copyright, you can't sue Twitter personally for the actions of one of its millions and millions of users. So how do you take advantage of these safe harbor provisions? Well, the first requirement is you have to designate a copyright agent to receive takedown notices. You have to adopt and communicate to users an effective copyright infringement policy. And number 3, you have to properly comply with the takedown notices when received. So there's a whole procedure of how you're supposed to handle takedown notices. Well, we'll get right into that. But first, let me also briefly mention what the process is for filing a DMCA takedown notice. So first, you receive notice. So let's say you see someone infringing your copyright on YouTube, you file a notice, and basically the rights holder sends a notice to the online service provider. So you send a notice to YouTube saying someone's infringing my content. Then YouTube has to remove that content from their platform. YouTube then has to notify the user who uploaded the infringing video, and then the user has an option to, accept the fact that their video is taken down, or they can file a counter notice, and then YouTube has to restore access to that material. So it has to re-upload the video, and that has to happen no less than 10 days and no more than 14 business days after the material is taken down or after you receive that counter notice, unless the original notice sender informs the service provider that it has filed a court action against the user. So if you think someone's taken down your video in bad faith and you file a counter notice, they're probably not going to file a court action. It's sort of like a bluff. They're saying, hey, take this down or else we're suing you. Then you file a counter notice and then you say, go ahead, sue me. Well, then they have to sue you. If they don't sue you, YouTube can't keep that video down. So here you have the US code and the section that basically addresses all of this DMCA stuff. Let's get into what some of the requirements are for a platform like Twitch. So here's one. You have to have a designated agent. So the limitations on liability established in this subsection apply to a service provider only if the service provider has designated an agent to receive notifications of claimed infringement. So you basically have to have someone to whom a copyright owner can send DMCA takedowns. So what are some other requirements here? Accommodation of technology. Platforms have to have some kind of policy for terminating repeat offenders. If someone keeps infringing on someone's copyright, you have to essentially have a policy that terminates their access to the platform entirely. And this is something we're going to look at with Twitch specifically because Twitch has a policy of 3 strikes and you're out. You have a permanent ban on your account after 3 DMCA strikes. So let's look at Twitch's policy and see if they're complying with this DMCA process. So here's the first thing we mentioned, a repeat infringer policy. So under our policy, a user will be considered a repeat infringer if they accrue 3 copyright strikes. Number 2, here we have the designated copyright agent. So this is the person you have to contact. Here you have an email account that allows the DMCA process to flow quickly. So one additional thing I want to mention is that fair use should be considered by the copyright owners before they file a DMCA takedown. And this creates some additional liability for the copyright owners, because if these companies don't consider fair use when it's a clear fair use, they could be liable for damages themselves and attorney's fees and certain penalties for misrepresenting their DMCA takedown. And why is that tricky? Well, if you've seen some of my other videos, you know fair use is very subjective. Different people can completely disagree on whether something is fair use. In other words, someone could think it's a closed case, someone could think it's an open and shut case. Fair use is all over the map and no one knows which way it's going to go. Except when you have Twitch streamers streaming entire episodes of MasterChef, I think that's a pretty clear example of something that's copyright infringement and not fair use. I think what we have here is there's going to be a complete change for how Twitch handles these DMCA takedowns. They might even revise their policy to have permanent bans after maybe only 1 or 2 strikes instead of 3 strikes. So there's sort of a dangerous mentality with Twitch streamers. A lot of them think that if they don't have 3 strikes, they're fine to infringe content because they still have leeway until they accrue those 3 strikes. But the reality is a company can sue any of these streamers whether they have strikes or not, whether they have a DMCA takedown or not. The takedown notice system is a safe harbor for Twitch and for platforms. It isn't a safe harbor for the users. It isn't a safe harbor for the content creators such as Pokimane. Only time will tell how companies will handle this, but once the story gets out there, every in-house legal department is going to say, well, is our content being streamed on Twitch? Let's start sending DMCA notices left and right. This might be a sticky situation for a lot of these Twitch streamers, and I do not envy being in their position, but it is something they should have been aware of, and it is pretty cut and dry if you look at the law as far as copyright infringement. Talk about loot boxes. If you've ever played a game such as Fortnite, Star Wars Battlefront, pretty much any game these days, you're familiar with the concept of a loot box. A loot box, at least as defined by Wikipedia, is a consumable virtual item which can be redeemed to receive a randomized selection of further virtual items or loot, ranging from simple customization options for a player's avatar or character to game-changing equipment such as weapons and armor. Loot boxes are something you purchase either with real money or in-game currency, which you acquire through real money, and sometimes certain tasks within games allow you to acquire this currency, but it's never at the same level as if you just used real money to essentially make your characters acquire different skins or equipment and outfits to make them look cooler, to make them more of a representation of your identity. In many ways, it's almost like accessorizing in real life, except it's in a virtual world. The issue with loot boxes is they're often targeted at children. Kids who want to stand out in their games, especially at games targeted for children, often use their parents' money to purchase these loot boxes. And because they don't have good impulse control at their young ages, they often become quite addicted to the concept of purchasing these loot boxes. Back in the 90s, we used to have trading cards like Pokimane and things of that nature where you essentially opened different packs and got excited about getting a holographic card or a rare card. It was one of the best feelings in the world for anyone who collected cards at a young age. Well, now you have these loot boxes where you essentially have rare boxes and ultra rare boxes, and they have different colors and they pop on the screen when you purchase them in the game. So it may come as no surprise that parents of children from around the country have filed lawsuits against various companies addressing this loot box issue. The argument is that loot boxes are a form of gambling, and gambling, unregulated gambling, is illegal. The concern is that these loot boxes create gambling tendencies and addiction in children, and they're targeted at children. So Google LLC became the latest company to fend off litigation alleging it encourages gambling through purchases of loot boxes and downloaded video games. So the essential claim was that loot boxes are illegal under state law, that they're a form of gambling. So how do you define an illegal slot machine? So 3 of the enumerated statutes within this lawsuit do define illegal slot machines, making clear that a slot machine is a device that gives the user a chance to win a thing of value. And this is really the key area that's going to be the downfall of this lawsuit. So the central argument here is, what is a thing of value? The plaintiffs insist that the loot boxes contain items that are of significant subjective value to those who play the games. If it's a thing of value to you, why shouldn't it be considered a thing of value? While the court is arguing there's a lack of any real-world transferable value to the items that takes them outside of the meaning of the statute. You can purchase a skin within the game, but you can't then take that skin and sell it on the street in the real world. So what's the solution if these items aren't things of value? So the solution to something like this is to seek legislative remedies. Certain other countries have actually passed laws like this, which prevent the sale of loot boxes for games that are catered to anyone under the age of 18. I can see how the court came out the way it did, but I personally, on a moral and ethical level, disagree with the conclusion, specifically because of that statement that a thing of value has to be something that can be exchanged for real world money. It's a well-known fact that a real world gray market exists where people gamble for and exchange different skins and different accounts for real financial benefit. Something that is sort of personal to me, and that's Activision finally cracking down on the company that's been distributing and selling cheat codes, essentially, for Call of Duty Warzone. If you've ever played Call of Duty Warzone, you know one of the biggest and most frustrating issues is the rampant cheating within the game. Players who purchase cheats have been able to essentially manipulate the game to their personal advantage by doing things such as automatically aiming weapons, revealing the location of opponents on the map, and allowing the players to see information that's not normally available to players because it would give them an unfair advantage in the game. In many cases, these cheats made the game pretty much unplayable, and it's one of the reasons I stopped playing the game myself. Now, when I used to play the game, I always thought to myself, if I was Activision, I would actively pursue these cheaters and sue the companies that are selling these cheats. And at the time, I didn't put much thought into it, but I considered some potential claims I would bring if I was Activision. I thought of some kind of interference with contract. So essentially, these cheat makers are interfering with a contract that Activision entered into with each person that purchased the game or is using the game. Now, whenever you start the game, and there was an update at some point that basically had a click wrap sort of terms of service that said you will not cheat in this game and you will not engage in purchasing cheats and using cheats for the game. So right there, by agreeing to play the game, you're also agreeing to the terms set out by Activision, which link to your Activision account, which in turn link to your email and Xbox Live account. Well, that's at least how I play the game, was through Xbox. But this essentially was a contract between you and Activision, which you agreed to. Cheat makers are actively trying to interfere with that contract that you entered into by selling cheats and marketing cheats and profiting off of you breaking that contract. In addition to this, I wondered if there was some kind of copyright infringement, because in order to create these cheats, the cheat companies must have had access to Activision's codes that they used to make the Call of Duty Warzone game, and they also must have somehow changed these codes and used these codes and created their own codes using copyrighted content. So let's take a look at this lawsuit. I haven't read through this at all yet, so I'm kind of curious and I want to react live with the audience, my viewers, and sort of see if Activision went with what my predictions were and what I would have done in this situation. So we have Activision Publishing Inc., a Delaware corporation, versus Engine Owing, a German corporation, and Doe's 1 to 50. So that means there's a lot of people being sued on an individual level. I'm wondering whether these are actual players and users that may have cheated. And I'm guessing all these individuals sued are members of the company, which is pretty surprising that they sued at an individual level. So complaint 4, trafficking in circumvention devices, intentional interference with contractual relations, and unfair competition. So this is the one that I was thinking of as far as a claim that I would bring, because they are interfering with that contract you made with Activision when you play the game. I'm not too familiar with the trafficking in circumvention devices, but I would guess that's somehow related to copyright and DMCA. So we have the basic information talking about the parties, who Activision is, nothing crazy there, pretty straightforward. So Engine Owning, the defendant, is a commercial online business enterprise consisting of German business entities and numerous individuals. EO is engaged in the development, sale, distribution, marketing, and exploitation of a portfolio of malicious cheats and hacks for popular online multiplayer games, most prominently the COD games, Call of Duty games. EO is also developing cheats for Overwatch, which is an Activision Blizzard game. The cheating software allows people to manipulate the games to their personal advantage. Nothing too interesting there. Let's keep going. In creating, marketing, selling, servicing, and distributing the cheating software, defendants have engaged in numerous unlawful acts under the United States and California law. Defendants have violated Section 1201 of the Digital Millennium Copyright Act, DMCA. Okay, so that's what I was talking about. 17 USC, Section 1201. By selling, importing, offering, providing, and otherwise trafficking in technologies that circumvent or evade anti-cheat technologies used by Activision. Defendants also have knowingly, intentionally, and maliciously interfered with and disrupted the contracts Activision has with its customers in the United States, which explicitly prohibit the exact type of cheating the defendants enable, encourage, and solicit by marketing and selling their cheating software. Defendants not only know that their conduct is unlawful, but they engage in conduct with the deliberate intent to harm Activision, its businesses, and its player community. So these are sort of the elements of tortious interference with contract that they're setting out here. So we're just going through who the parties are, and looks like several of the Doe defendants may be aliases of EO staffers. So they're not going after the players, they are going after some various staffers. So look at this. Among the defendants are developers, resellers, technical support staff, other individuals who have participated in the development, sale, and distribution of the cheating software. All these defendants are liable as a result of their participation in all or some of the acts set forth in this complaint. They're really going all out, really going after everyone. If players perceive that a game is unfair, including because others are cheating or have an unfair advantage, players may grow frustrated with the COD games, like me, become less interested in playing, like me, and supporting them, including by purchasing new games and items, and may even stop playing entirely, like me. Cheating therefore not only harms and could even destroy COD player communities, but also impacts Activision's ability to offer the fast-paced, stable, high-quality online gameplay to which millions of fans have become accustomed. In order to access, download, or play the COD games, users must create and register accounts with Activision. Upon first playing the COD games and beginning installation, users must expressly manifest their assent to Activision's terms, which include, I'm guessing, that you're not going to cheat. Among other provisions, by assenting to the TOU, terms of use, users expressly agree not to use, develop, host, or distribute cheats, automation software bots, modified lobbies, hacks, mods, or any other unauthorized third-party software. It is not possible for a user to lawfully obtain access to or play the COD games online multiplayer modes without expressly consenting to the terms of use. Each time a player uses the cheating software to cheat in COD games, he or she violates Activision's terms of use. Accordingly, Activision is informed and believes on that basis alleges that as a result of defendants' conduct, at least tens of thousands of breaches of these contracts have occurred. Defendants are fully aware that the use of the cheating software violates the terms of use. For example, this is good, the EO website prominently warns users that they can be manually banned by Activision for obvious cheating. So they clearly know it's against the terms because you can be banned. Thus, defendants' goal is to ensure that their customers continue to receive the benefits of their contracts with Activision while they simultaneously engage in continuing breaches of their obligations under these contracts. So let's get into the actual counts and the actual claims here. Count 1, trafficking and circumvention devices. This is the one I'm not really familiar with. The COD games, including but not limited to their source code and audiovisual gameplay environments, are copyrighted works, so it is a copyright related claim. I want to see where they actually say what the statute's language is. I mean, I can look it up, but I'd rather it should be in the complaint itself. No person shall manufacture, import, offer to public, provide, or otherwise traffic in any technology, product, service, device, component, or part thereof that is primarily designed or produced for the purpose of circumventing a technological measure that effectively controls access to a work protected under this title. So a work protected by copyright, I'm guessing. Has only limited commercial significant purpose or other use than to circumvent a technological measure, or is marketed by that person or another acting in concert with that person's knowledge for use in circumventing a technological measure that effectively controls access to work protected under this title. To circumvent a technological measure means to descramble a scrambled work, to decrypt an encrypted work, or otherwise to avoid, bypass, remove, deactivate, or impair a technological measure without the authority of the copyright owner. I think this is a pretty straightforward. They have a technological measure that's protecting their copyrighted work, and you're infringing with that measure for no other purpose than to infringe. No other significant commercial purpose than to infringe, and it's marketed for that reason. All right, next one. Intentional interference with contractual relations. Activision's contracts with users are valid and enforceable. Each time a user cheats, he violates the terms of use. Defendants are aware of both the existence and specific relevant terms of contracts between Activision and its users in the US. By inducing Activision's users to breach their contracts with Activision, defendants have intentionally interfered and continue to interfere with the contracts between Activision and its users. Defendants are guilty of oppression, fraud, or malice, and Activision, in addition to its actual damages, by reason thereof, is entitled to recover exemplary and punitive damages against defendants. That's always an interesting thing when you request that. That means you are not happy with what the other side is doing. You're particularly not happy with what they're doing. Pretty straightforward lawsuit, if you ask me. There's clear statute on point about circumventing these protective measures. There's a clear contract in place between Activision and its users. On its face, this complaint is plausible as to the fact that the company clearly knew about these terms and it didn't care. And in fact, it specifically said that you could get banned. So that means they must have known about the terms, and they specifically helped prevent the enforcement of the contract because it helped people avoid detection in order to not get banned. I'm really glad Activision is finally pursuing these cheating companies. It's kind of ridiculous that it took them, I don't know how many years to actually pursue this, but I'm curious how this goes. I'm curious to see what their response is going to be. I can't even imagine what their counterclaims are going to be or what their responses and replies are going to be to this lawsuit. Who knows? Lawyers can get creative, and I'm sure there's a lot that I haven't researched. I'm coming into this pretty fresh, so who knows what they're going to argue in defense, but thank God it's happening. I've been waiting for this for a long time. Probably too late for me to go back to the game, but hey, it's a good sign for future games, and it might set a good precedent for having a fair and enjoyable gaming experience in the future for all kinds of games that might succumb to cheating and things of that nature. Well, until next time, this is Reels and Gavels.